seated. We're playing musical chairs. We're playing musical chairs, yes. All right, Leader of the Opposition.
Madam Speaker, thank you for giving me the opportunity to intervene on the Certificate of Character Bill, and I shall be brief and to the point, Madam Speaker. Allow me at the very outset, Madam Speaker, to say that we support the principle behind the bill. We believe in rehabilitation and we believed in second chances, Madam Speaker. Madam Speaker, we recognize that a criminal record, particularly for minor, in relation to offences which have taken place a long time back, do create some impediments to employment, housing, and most importantly, dignity, Madam Speaker. These barriers, if left unaddressed, may paradoxically increase the risk of reoffending. We also, Madam Speaker, acknowledge that the bill's stated objective is specifically to reduce these barriers and facilitate social integration, which is necessary for our society. Now, let me start by highlighting some positive measures which render this legislation less stringent and which will help abate, if not eliminate, those impediments I mentioned earlier. Firstly, Madam Speaker, the increase in the fine threshold for eligibility from 5,000 to 50,000. Secondly, the waiting period, which has now been reduced from 5 to 2 years, Madam Speaker. And lastly, the fact that with this upcoming legislation, persons sentenced to imprisonment of up to 3 years may receive a clean certificate after 10 crime-free years. And also, Madam Speaker, we note that youth offences committed under 18 are now automatically excluded from disclosure, and these are, like I said, positive aspects of this piece of legislation. It is also to be noted that Clause 4 of the bill introduces, like earlier the Attorney General stated, a statutory prohibition against employment discrimination where a conviction is not related to the role. Now, Madam Speaker, although this is a positive step, it suffers from an intrinsic defect in the way it has been formulated, and its application is likely to be unpractical and may lead to an inconsistent approach. And let me explain, Madam Speaker. First of all, legislative process on paper does not automatically translate to actual liberation on the ground. The critical question before this House today is not whether this bill is less stringent, but whether it will ultimately achieve its aim of effectively reducing the barriers to employment and social integration. Unfortunately, Madam Speaker, the answer is no, as this bill carries unintended disadvantages. Let me illustrate what I just said by referring to the following clauses of the bill, and I'll refer to the clause I mentioned earlier, that is Clause 4, which deals with non-discrimination and the employment barriers, because I believe that this clause is structurally ambiguous, Madam Speaker. The bill, as it is, prohibits discrimination only where conviction is not related to employment, yet what we note that this bill provides no criteria, no guidance, and no fast-track adjudication mechanism. Employers are thus left to make complex legal judgments in isolation, and its unintended but natural result would be a utter confusion and lack of understanding in giving effect to that particular clause. Madam Speaker, I fear that without a statutory code of practice from the Equal Opportunities Commission and an accessible complaints process, this provision runs the risk of being symbolic only. Worse, Madam Speaker, employers' uncertainty may lead to over-compliance, thereby rejecting all applications with disclosed convictions or informal background checks that bypass the certificate altogether. Madam Speaker, let me now turn to Clause 6 of the bill, which deals with the administrative capacity and the role of the Director of Public Prosecution. This clause centralizes the issuance of character certificates by the Office of the Director of Public Prosecution. Although this may enhance consistency, on the other hand, it raises serious capacity concerns, Madam Speaker. The Director of Public Prosecution constitutional mandate is prosecution, not high-volume administrative certification. Madam Speaker, I fear that if there is a surge in applications submitted to the DPP's office, this might give rise to processing delays and create a new bureaucratic barrier, Madam Speaker. And it goes without saying that going through the red tape would, in fact, obstruct progress and hinder efficiency. Madam Speaker, the bill correctly notes that a free pardon under Section 75 of our Constitution results in a clean certificate. But we must be precise. This bill mechanism is not a pardon. It is what is referred to as an administrative spent conviction, whereby certain convictions become spent or are not disclosed after a period of time. This is a totally, Madam Speaker, different concept. Any attempt to combining the two risks, compromising and eroding the solemn constitutional prerogative of mercy, which the House should know is reserved for exceptional cases of injustice or extraordinary rehabilitation. Furthermore, Madam Speaker, the exercise of the prerogative of mercy in Mauritius has, in recent years, been the subject of public debate concerning transparency and accountability. Madam Speaker, I strongly believe that the time has come to consider legislative or procedural reforms to ensure that the advice of the Commission on the prerogative of mercy and the reasons for the President's decision are made public. But, having said that, it should be subject to necessary safeguards for privacy and national security, Madam Speaker. You may feel able to agree that this would be a major step in increasing public confidence in the system. Madam Speaker, the bill introduces a QR code verification and a dedicated digital platform. Although this is a positive step, unfortunately, it raises a series of questions as it lacks explicit data governance provisions. For example, who controls access to the underlying database? How will spent convictions be securely archived or deleted? What are the safeguards in place designed to prevent misuse by authorized authorities? And the bill does not provide any formal appeal mechanism for individuals who believe their certificate incorrectly discloses a conviction. Madam Speaker, let me conclude. Like I said, I'll be brief by saying that the measure of a just society is not only how it punishes wrongdoing, but also how it offers a pathway back to citizenship for those who have erred and served their debt. This bill, no doubt, like I said earlier, represents a step in the right direction. But, Madam Speaker, a step taken without safeguards and without practical and full enforcement mechanism will fall short of its promise. I'm done, Madam Speaker.
Thank you very much. Thank you. So now we have the Honourable Minister of Labour.
Thank you, Madam Speaker. Madam Speaker, when I listened to the Honourable Leader of the Opposition, he always failed to justify why in the past 10 years that his government was in power, they didn't do anything. And now when this government is trying to do something, he's always criticizing us. Let me remind the Honourable Leader of the Opposition. As far back as the 8th of September 2015, when his party was in power, MSM was in power, this is what the Honourable Attorney General then said. The question was about when would Amendment 2, the Certificate of Character Act, be proposed. He stated, "My office has started consultation with relevant stakeholders in relation to the amendments to be brought to the Certificate of Character Act." That was 2015. Then 2016, same Attorney General, he says that as stated in the government program, legislation will be coming to Parliament. We are envisaging possibly even to avoid stigma, maybe looking into equal opportunities as being amended as well, but legislation will be forthcoming. Again, in September, 2016, honourable member will note that in line with government program, legislation will be forthcoming because we are very concerned with the present state of affairs as well. And it goes on and on like this. Every time members of the opposition had asked questions about certificate of character, every time they keep saying the same thing. 13th June 2017. I wish to assure, that was the Honourable Attorney General then of the MSM, I wish to ensure, so what does it mean assure, the House that amendment to both Certificate of Character Act and, as I will say, there are other acts as well, I will mention them shortly, will be brought to this House by the end of this year, time permitting. That was back in 2017. So they keep saying that they will amend, they will bring changes, but they never do. So he had taken this government, who now, are coming with the appropriate legislative change to correct an essential unfairness. Madam Speaker, according to Statistics Mauritius, as at June 2025, out of 5,078 adult convicts admitted in prison in 2024, some 3,728 were re-offenders who had been in prison in the past. That is 73.4% of convicts tend to re-offend. In an article published by the lecturers from the University of Technology Mauritius entitled Trends in Incarceration and Recidivism in Mauritius, Raising the Alarm, the authors identified the main challenge for rehabilitation and reintegration of ex-detainees as the certificate of character, which was an obstacle for gaining employment. This is why, Madam Speaker, The main purpose of the bill is precisely to reduce barriers to employment and social integration of persons who have been convicted of an offense. But it's not only about employment. You know, when I was practicing a few years ago, a student came to see me. The student wanted to apply for a seat in the university. He had excellent grades, but he was very concerned because he had smoked in public. And because he had smoked in public, he had a fine. And because of that fine, he was at risk of not securing a seat in the university outside of Mauritius. And we did what we had to do, which is petition to the president through the Commission of the Prerogative of Mercy. We managed to secure a pardon, but it takes time and it takes costs. Another student came to see us only 3 years ago. She was apprehended for shoplifting. And although she had always claimed to be innocent, somehow she was not represented, and she managed to find herself on the same day in front of a court pleading guilty and getting a fine for larceny. Then she decided to get married. And because she was getting married to a foreigner, she was not going to get the necessary visa, the necessary residence permit, because of that incident, of which is always claimed to be innocent. Again, we had to go through the same system of applying to the president for through the Commission for Prerogative of Mercy to get a parole. But today, with this law, we are changing it. Today, with this law, any offences committed by a juvenile before the age of 18 will be expunged from the certificate of character. It will not appear anymore. Petty offences like larceny will no longer appear on the certificate of character, because previously, even if you had only a fine, if it was larceny, it had to appear in your certificate of character. So there are other offences, for example, drug-related offences, smoking cannabis, ganja, small possession of ganja for consumption. You know, a lot of people have been caught with that. As they say, erreur de jeunesse. And then that stigma stayed with them all along, throughout their life. There was no remission, no possibility of expunging this conviction, however, you know, mundane it may look today, from the certificate of character. So I commend the Honourable Attorney General because he did a real balancing act when he came with this legislation. There are serious offences, that is in Schedule 1. Serious offences that will appear on your certificate of character, what come may. Even if you have only a fine, even if you did not have imprisonment, it will always be there because society recognizes the seriousness of that offense. And that is very important. I'll tell you why. Let's suppose tomorrow someone is applying to the Ministry of Gender Equality to be a foster family or to act for adoption. And that person, you know, many years ago was convicted for sexual assault over a juvenile or any other crime against the children. Obviously, this is a very material consideration to be taken into account when deciding whether to allow that person, like God, to become the foster parent of a minor child. If I am a banking institution and I'm going to employ someone who's going to deal with money, I need to make sure that that person has not been convicted of an offense involving dishonesty. Similarly, if someone is going to travel outside of Mauritius, another country would want to know if that person in Mauritius has been convicted of a serious offense like terrorism or other activity which may put their country, the security of their country, in jeopardy. So this is the first balancing act, making sure that in the first schedule we have a list of major offences. And that list has been updated because since 2012, there have been new legislation. So we need to include those new offenses that has been created. Then what this schedule does, he removes certain offenses which we consider are no longer serious offenses. To give the example already quoted by the Attorney General, possession of drug or offenses of larceny. And then, as the honourable leader of the opposition rightly pointed out, the major change in this legislation is, for the first time, a person who has been sentenced for imprisonment up to 3 years, other than for a major offence in the first schedule, for the first time, that person will have the chance to have a certificate of character not mentioning his conviction for imprisonment after 10 years. That's a big relief for a lot of people who have spent their time, they have spent their conviction. Now, the honourable leader of opposition take exception for Section 4, which deals with equal opportunity when someone looks for employment. May I remind the honourable leader of opposition that a similar provision already exists under the Equal Opportunities Act. The major difference between the provision that exists under the Equal Opportunities Act and what we're introducing is that under the Equal Opportunities Act, you cannot discriminate against someone who has been convicted of an offence which is irrelevant. The term used in the Equal Opportunities Act was irrelevant to the job that you have applied or the job that you're already in. Now, there was this amount of subjectivity when you use irrelevant, because the employer can always say, you know, for you it may not look irrelevant, but for me subjectively it is very relevant that you smoked ganja 15 years ago. Now you are replacing that subjective element with an objective criteria, which is the offense must not be related to the job. So even if you had smoked ganja in the past, if whatever job you're going to do has absolutely nothing to do with erreur de jeunesse that you've done, you cannot be discriminated against. Now, the only opposition says that the law does not provide for any sanction. Again, because he doesn't know how this works. This law works hand in hand with the Equal Opportunities Act. And the Equal Opportunities Act already provide any employee, worker or prospective employee who feels that he has been discriminated on the basis of a conviction, he has to apply to the Equal Opportunities Commission, who carry out an investigation. And then the Equal Opportunities Commission refers the matter to the Equal Opportunities Tribunal. And it is the Equal Opportunities Tribunal who has the power to sanction, including imposing fines and sending people to jail and other remedial action. So there was absolutely no reason to include all these provisions again in the Certificate of Character Act, because it's already in the Equal Opportunity Act. Then the leader of opposition talks about QR code, talks about data protection, talks about, all these lack of security, of safety. But if the honourable leader of the opposition had taken the time to look at the existing law, the existing Certificate of Character Act of 2012, he would have found out that these provisions already exist in the law. Already you do an application online electronically, and already if you look at the schedule, you will see the QR code. It's already being operating like this. So nothing will change. If anything, things would improve. He's saying that the DPP does not have the staff, but that is why the DPP has the power to delegate. And in fact, if he had gone through the system, if he had taken the time to ask the people, how do we get a certificate of character, he would have found out that today it is the police which has the greatest responsibility. Because whenever there is a conviction, there is a central database at the police. So the prosecutor is the one, the police prosecutor is the one who would take the conviction, the report, and send it to the centralized system, not the DPP. The DPP does not have record. So whenever there is someone who applies for a certificate of character, the DPP is going to ask the police to retrieve the information from the database of the police, which is in a secured location with all the necessary protection, including data protection. So it is not the DPP. So I'm just informing the leader of the opposition because obviously he has no clue about how a certificate of character is applied, how it is delivered. Madam Speaker, I'm not going to be long. I wish to put on record my sincere thanks for the Honourable Attorney General to bring this very important legislation, not even 2 years into our mandate. And I have no doubt that with this piece of legislation, a lot of people who have been denied access to a job, who has been denied the ability to be reintegrated, to be reinserted in society, will have a second chance. Thank you.
Thank you very much, Minister. Now we have Honourable Ms. Delgado.
Thank you, Madam Speaker. Madam Speaker, I rise today to contribute to the debate on the Certificate of Character Bill. I have carefully listened to all honourable members in this House, and it appears it is clear that at its heart, Madam Speaker, this bill asks an important moral and social question. Whether one single mistake after years have passed, after punishment has been served, should continue to block a person from decent work, dignity, and a place in society. This bill, Madam Speaker, answers this question, at least in part, by saying no. What we are called to consider is not whether consequences should ensue, they should, of course, but whether those consequences should endure indefinitely without regard to time, reform, or rehabilitation. Madam Speaker, I also I have listened to Honourable Utim, who has shared his experience as a barrister, and I will also admit that during my years of practice at the bar, I have witnessed individuals who have been for too long trapped in a cycle of rejection, not because of who they are today, but because of who they were once. So this is why, Madam Speaker, to me personally, I consider this bill to be humane and very meaningful reform. I have witnessed opportunities denied, families strained to breaking point. Consequences have been denied always, Madam Speaker, just because of that single piece of document known as the Certificate of Character. Each attempt by many people, because of one single mistake, end up the same way, denied, dismissed, or discarded. And this is why, Madam Speaker, I say that second chances must be real. They shouldn't be merely spoken about. I am sure we have all in this House seen and witnessed so many people and families who have gone through the quiet devastation of caused not by a code of law, but by the lingering shadow of a document, the Certificate of Character. Recently, the LGSC recruited, and we all know how many couldn't secure the job, not because they were not competent, not because it was related to the job, but because their Certificate of Character showed that they had a criminal record. So, of course, I am not saying that justice must lose its seriousness. This is not what I'm saying. I'm saying that justice must not lose its humanity. And as the leader of opposition rightly pointed out, a just society must know how to punish wrongdoing, but it must also know when to build, to allow a human being to rebuild. This bill, to me, congratulations to the Attorney General, recognizes that justice must evolve beyond punishment and embrace rehabilitation. It acknowledges that those who have shown genuine remorse, rebuild their lives, serve their sentence, deserve more than perpetual exclusion. They deserve a real opportunity to reintegrate into society. It is finally about ensuring that one mistake does not become a lifelong sentence. You would agree with me, Madam Speaker, that the human impact can be big. We've seen it in our constituency recently when people couldn't secure a job. I recall myself, Honorable Utim gave the example of possession of cannabis, ruining people's lives for the purposes of consumption. You gave the example of a small larceny. And I remember meeting a young guy in his early 30s who had been involved in a tragic accident. He was driving at the time. He deeply regrets what happened. There was no question of alcohol or intoxicating substance. To him, it was a moment of poor judgment that led to the tragic loss of life. That person was so traumatized by what happened, Madam Speaker, that he stopped driving altogether. He was by now, when he met me, he was by now a dutiful son, a responsible husband, a devoted father, but yet he explained to me how, because of that one single document, his life was defined forever. He could not get a decent job and people misjudged him. So, and this made me reflect, Madam Speaker. We've all been asking questions here. This made me reflect, how can we speak of rehabilitation if we deny reintegration? How can we as a society and even as legislators speak of reducing unemployment while quietly shutting the doors to people willing to work? This is why I reiterate, I welcome the bill's express protection against discrimination in employment and for prospective employment. This is, to me, one of the most socially constructive parts of the bill. Too often, the leader of opposition recognizes this fact. Too often, exclusion from work has been one of the greatest barriers to real reintegration and rehabilitation. And I think you will all agree with me, if we want safer communities, we must also want pathways back to lawful work and self-respect. A society that leaves no room for redemption should not be surprised when it struggles to achieve rehabilitation. And I am not saying, of course, Madam Speaker, maybe people might misinterpret. I'm not saying that we should remove proper safeguards. They should be here. And let us be clear, this bill does not wipe away serious crimes. Serious crimes will still remain on the certificate of character through the first schedule, and the Attorney General has stated it. What offences will remain in the first schedule and on the certificate of character? I'm citing a few offences involving children, terrorism, major criminal code offences, such that it is clear dangerous offenders will not benefit from this reform. But for those who have committed lesser offences, those who have reformed, rebuilt, this bill gives them something profoundly important, a second chance and a genuine one. So this bill, Madam Speaker, reflects an important shift. It is more proportionate approach, distinguishing between seriousness and lesser offending. It distinguishes between risk and rehabilitation, and it distinguishes between permanent danger and genuine reform. I have also gone through section 5 of the bill, which is the major central reform clause. It is, I will not go through it again. To me, some may say this is leniency. It's not leniency, this is fairness. And I also welcome the section regarding young offenders. This is fair and forward-looking, Madam Speaker, because we have to agree that youngsters do make mistakes, but they also have the capacity to change. And if we want a balanced approach, that is the correct one that protects society while also investing in the potential of our youth. So while support in principle, Madam Speaker, while support in principle is good, but then I will want to scrutinize the detail. I only have one remark, and I do not know if the Attorney General will be able to consider that through the regulations. There is a broader point we have to reflect on, is the efficiency of our system, Madam Speaker. So this is why I will urge the Attorney General, through the regulations, to impose a deadline within which the certificates will be issued following an application by a citizen. And because at the end of the day, Madam Speaker, when we say that a system that aspires to fairness should also aspire to timeliness. So I will not be longer than that. I will sum up by saying that while urging careful attention to safeguards in implementation, I support this bill because to me, Madam Speaker, it reduces barriers to employment, it promotes social integration, family stability, reduces reoffending, and ultimately creates a safer and more inclusive society. I cannot end without congratulating the Attorney General and the government for coming forward with this reform. And as we say at the end of the day, a country is not judged only by how firmly it punishes and condemns wrongdoing, Madam Speaker, but also by whether it leaves room for reform, responsibility and return. I commend the bill to this House. Thank you.
Thank you very much. We're doing very well from the time point of view. Honorable Babulal.
Thank you, Madam Speaker, for allowing me to participate in the debate. Madam Speaker, the Certificate of Character Bill 2026 seeks to repeal and replace the long-standing Certificate of Character Act 2012. I thank the Attorney General for bringing in the bill. This is a way forward. Madam Speaker, at the outset, we acknowledge that updating outdated legislation is a necessary function of this House. The 2012 Act has served for over a decade. However, the current system has at times proven fragmented, inconsistent, and vulnerable to delays and misuse. That said, this bill goes beyond mere modernization. It fundamentally reshapes how we treat individuals with criminal convictions in our society. Madam Speaker, in this bill, as has already been enlightened by my learned friend barristers as well, the clauses 4 proposes non-discrimination in employment. Clause 5, which is one of the main clauses, subsection 1A to G, relates to certificate of character with no criminal record, but the offender should not fall under the first schedule. Clause 6 is where the certificate of character will be issued with criminal record if none of the circumstances in clause 5 is applicable. There's also a consequential amendment by clause 12 in relation to the Equal Opportunity Act. Madam Speaker, the certificate of character is not merely an administrative document. For many citizens, it is a gateway to employment, education, travel, immigration, and professional licensing. Under the previous law, all convictions could appear on the certificate, often creating permanent and disproportionate barriers, particularly for minor offences. For many individuals, these documents determine whether they are afforded a second chance. Madam Speaker, we support measures that enhance public trust and national security. Integrity in public life and employment is essential. However, legislation must strike a careful balance between safeguarding society and protecting fundamental rights. While we support this principle of the bill, there remain some questions that merit clarification. Madam Speaker, our society believes in second chances. A person who has paid his or her debt to society should have a realistic opportunity to rebuild their life. Clause 5 introduces reforms aimed at reducing barriers to employment and social reintegration for individuals with minor convictions who have demonstrated good conduct. This reflects the principles of fairness, proportionality, and rehabilitation. Madam Speaker, legislation must not only protect society, it must strengthen it. And society is strengthened not by permanent exclusion, but by responsible reintegration. The bill does not define clearly and outline how to rehabilitate people. Madam Speaker, Clause 6 raises some concerns. If not carefully administered, the system risks creating what we may perceive as a way of perpetual punishment. A certificate regime that continues to heavily penalize individuals without adequate mechanisms for review, expungement, or meaningful rehabilitation may ultimately increase recidivism rather than reducing it. Madam Speaker, the bill also strengthens anti-discrimination protection by amending Section 10 of the Equal Opportunities Act. Employers would be prohibited from refusing employment solely on the basis of a conviction unrelated to the job offered, provided there is no real risk to the employer's operation or reputation. This is a progressive step, but not without setbacks. Madam Speaker, public safety concerns must also be addressed. While easing restrictions on minor convictions promote reintegration, certain sectors, particularly financial institutions, and positions requiring high level of trust may require greater transparency. The bill is largely silent on how such sectors are to balance non-discrimination with legitimate risk assessment. This tension requires clearer legislative guidance to specific risk sectors. It is of utmost importance to discuss whether certain sectors like banking, childcare, and elderly care should have a specialized access to full records, as the current bill's general, less stringent approach might not account for the high level of trust required in these specific roles. Madam Speaker, balancing these rehabilitative goals with public safety and the concerns of employers draws a robust line of reasoning on the reputation against reintegration. Tensions are inherent in the bill. The reputational risk loophole may emerge. This could allow employers to bypass the anti-discrimination intent of the bill by claiming any past conviction, however minor, that harms their corporate image. Madam Speaker, another area requiring some clarification concerns the prerogative of mercy under Section 75 of the Constitution. Clause 5 recognizes that a person who has been granted a free pardon may obtain a certificate without criminal record. However, some questions arise. Can an individual apply immediately to the Commission on the prerogative of mercy following sentencing without waiting for the lapse of the time required by under Clause 5? Does Clause 6 imply that a certificate with criminal record remain for life? Can a pardon not be granted in these circumstances? Does it stop someone from applying to the Commission on the prerogative of mercy? If ever a free pardon is granted, where do we draw the line in relation to this bill? How does this interact with the judicial review by the DPP? Madam Speaker, in De Boucherville, Roger against the State 2009 SCG 5, the Supreme Court reaffirmed principle established in Pungavanam against the Commission on the Prerogative of Mercy 1999 SCJ 396, holding that decisions of the commissions are amenable to judicial review where constitutional breaches occur. The court recognized the quasi-judicial nature of the commission's functions and emphasized that its power must be exercised with rigor, integrity, and honesty. Madam Speaker, given that the Commission may effectively alter court-imposed sentences, the safeguards surrounding its decision are fundamental to preserving the separation of powers and public confidence in the justice system. There are growing discussions internationally about a strengthening oversight mechanism over executive pardon powers to ensure appropriate checks and balances. This is a golden opportunity to address this issue as well, because this bill will directly or indirectly affect the Commission on the prerogative of mercy. Madam Speaker, while the bill allows for the omission of convictions involving up to 3 years of imprisonment, it requires a 10-year clean record. On the other hand, it can also be argued that a decade is too long for someone trying to re-enter the workforce immediately after serving the time, potentially leading to recidivism due to lack of opportunity if there is no rehabilitation program. Madam Speaker, governance must evolve with a modernizing nation. The Certificate of Character Bill 2026 reflects an effort to modernize our legal framework and protect civil liberties. Its objectives are commendable. However, clarity, safeguards, and precision are necessary. Madam Speaker, we support the bill, and in relation to ensure that the Certificate of Character system protects society, promotes responsible second chances, and uphold dignity and rights of all Mauritians, and for us to have a better criminal justice system. Madam Speaker, with those observations, I commend the bill to the House. Thank you.
Thank you. Thank you, Mr. Babaji, Honorable Babaji.
Thank you, Madam Speaker. Madam Speaker, let me first of all thank the Attorney General for his commitment to introduce this bill to this House. And before starting, let me remind everyone here that before 2006, there were no laws in regards to moral certificate. And it's only this government, this Prime Minister, the Honorable Navin Chandra Ramgoolam, who brought the Certificate of Morality Act 2006. And it's only after 6 years, 2012, again, the Labour Party, the Character of Certificate Act was introduced when repealed the other one. And from 2014 to 2024, the previous government had 10 years to review, to adjust, to review all the defects, but nothing was done. As my colleague just said, the Honorable Rezautim, every time law were being introduced, proposal, everything, but nothing done. But today, the present attorney, he got that courage to bring it within 2 years in power. Yes. And we need to thank him for his courageful decision. Madam Speaker, today I lend my full and unequivocal support to the Certificate of Character Bill, a piece of legislation that goes to the very heart of justice, fairness, and human dignity in our Republic. This debate invites us to reflect not only on law, but on the values that underpin our society: compassion, fairness, and the belief in human redemption. The proposed repeal of the Certificate of Character Act 2012 and its replacement with a more balanced and humane framework marks a decisive step towards restoring dignity and opportunity to those who have long been defined and confined by their past mistakes. For too long, a document intended to reflect a person's character has instead functioned as a lifelong barrier. A single conviction, often for a minor offense, has trailed individuals for years, if not decades, closing the door to employment, limiting access to education, and obstructing meaningful reintegration into society. This bill recognizes a simple yet profound truth: people can change. Madam Speaker, under the new provisions, individuals who have committed minor offenses resulting in small fines or short terms of imprisonment, will no longer carry that burden indefinitely. After a reasonable and just period, such records will no longer appear on certain certificate of character. This is not about erasing wrongdoing, it is about recognizing growth. It is about acknowledging rehabilitation, and above all, it is about granting second chances. We must, in particular, Madam Speaker, consider the impact on our youth. A mistake made before the age of 18 should not cast a shadow over an entire lifetime. Youth is a time of learning and sometimes of error, but ensuring that such mistakes do not permanently stain a young person's future. We give them the opportunity to rebuild, to contribute, and to succeed. And yet, Madam Speaker, what have we seen the last 10 years, from 2014 to 2024? We got that synthetic drugs coming in our society. We got all those small youngsters consuming those synthetics, getting caught with those drugs, getting caught with cannabis. And this is the decision why he took this decision today, to facilitate those people to rehabilitate in our society. And under the able leadership of our Prime Minister, this government has demonstrated a clear commitment to building a fairer and more inclusive society, one that balances accountability with compassion and discipline with opportunity. Madam Speaker, one thing we need to ask, is this justice like it is now? Or is it a system that punishes not once, but repeatedly? We must confront an uncomfortable reality. When we deny individuals a fair opportunity to reintegrate, we do not merely punish them, we marginalize them. We risk punishing them towards despair, towards exclusion, and in some cases, towards the very path we seek to prevent. A young graduate denied employment despite merit may lose hope. A reformed individual repeatedly rejected may feel abandoned by the system. And in that void, the dangers of social evils, drug abuse, dependency, or criminal influence become ever more real. As my neighbor just said, how many people were rejected to work at the LGSC? If we imagine just to collect refuse, those people were denied jobs only because of the character certificate. Madam Speaker, there are deeply troubling cases of students who, during their formative years, committed minor infractions. Today, they are educated, reformed, and ready to contribute. Yet, they remain excluded because their certificate of character continues to reflect those past errors. This bill represents a compassionate and principled shift in our legal framework. It affirms that justice must not end at punishment, it must extend to rehabilitation and reintegration. It is fundamentally unjust that individuals who have been granted a free pardon or who have been discharged, whether absolutely or conditionally, should continue to suffer the consequences of those offences through administrative barriers. This bill corrects that imbalance. Let me be clear. This reform does not weaken the rule of law, Madam Speaker. It strengthens it, because true justice is not only firm, it is fair. It does not only punish, but it also restores. Madam Speaker, I wish to thank the Honourable Attorney General for bringing forward this timely and necessary reform. It reflects a clear understanding of the life realities of our citizens and a genuine commitment to building a more inclusive and equitable Mauritius. Behind every certificate, Madam Speaker, lies a human story, a story of error, yes, but also of growth, of effort, and of determination to do better. Let us not allow the mistakes of the past to become permanent barriers to the future. Let us instead affirm through this bill a principle that is both simple and powerful, that a person is more than their worst mistake. Let this House send a clear and unwavering message today. Mauritius believes in second chances, Mauritius believes in fairness, and Mauritius believes in its people. Madam Speaker, I wholeheartedly support this bill. I commend it to the House.
Yes, Honourable Ahmad
Yes,
Diaz.
Madam Speaker, I beg to move for the adjournment of the debate.
Thank you. The question is that the debate be now adjourned. Those in favour say aye. Those against say no. The ayes have it. Prime Minister.
Madam Speaker, I beg to move for the adjournment of the House to Tuesday, the 28th of April at 11:30 a.m.
Thank you. The House stands adjourned.